One of the biggest misconceptions I hear from people is this: how is he going to prove he didn't do it? That's the wrong question. In an American criminal case, the defendant doesn't have to prove anything. The government has to be the one to prove everything. And that's not some technical legal rule that lawyers came up with to help guilty people get away with crimes. It's one of the most important protections we have as a free people. The reason is simple. Think about everything the government already has at its disposal: police officers, detectives, crime labs, prosecutors, search warrants, subpoena power, investigators, expert witnesses, the ability to compel people to come to court. Vast resources that no individual could ever hope to match. If all of that still isn't enough to prove someone committed a crime beyond a reasonable doubt, then that person should not be convicted. That's exactly how the system is supposed to work. Every criminal case begins with the defendant being presumed innocent. Not probably innocent, not innocent until we hear from the police. Simply innocent. That presumption stays with the defendant unless and until the government proves guilt beyond a reasonable doubt. And because of that, the defendant doesn't have to testify. The defendant doesn't have to call witnesses. The defendant doesn't have to explain a single thing. The defendant doesn't have to prove an alibi. The defendant doesn't have to prove someone else committed the crime. The defendant doesn't even have to present a single piece of evidence. Now, that doesn't mean that a defense attorney never presents evidence. Sometimes we do. Sometimes it's absolutely the right strategic decision. But we never have to. The burden always stays where it belongs, on the government. One thing I wish more people understood is that there is a huge difference between these two statements. I think he probably did it, and the government proved it beyond a reasonable doubt. Those are simply not the same thing. In fact, a juror can believe that someone probably committed a crime and still be required to vote not guilty. Why is that? Well, because probably isn't the standard. The question isn't whether the defendant is probably guilty. The question is whether the government has eliminated every reasonable doubt. And those are completely different questions. I've represented clients where at first glance the evidence looked pretty strong, but when you slow down and examine it carefully, you find gaps. Witnesses who don't agree with each other, evidence that doesn't quite fit, assumptions that investigators made without actually proving them, missing pieces. And those gaps matter, not because my client has to fill them, quite the opposite. Those gaps matter because it's the government's job to eliminate them. If those gaps leave a reasonable doubt, then the government hasn't carried its burden of proof. Here's another way to think about it. Imagine your surgeon says, "I'm about 80% sure that this is the correct procedure." Would that make you feel comfortable? Probably not. When the consequences are serious, we demand a high level of certainty. In a criminal case, the stakes are someone's freedom. Sometimes we're talking about decades of a person's life. Sometimes we're even talking about their life itself. It shouldn't be easy for the government to take that away. One of the biggest mistakes innocent people make happens long before they ever get to a courtroom. They think, well, if I just explain myself, they'll realize I'm innocent. Look, I understand why people think that. It's a very human instinct, and we've been conditioned and socialized to think that the truth will set us free, which is unfortunately not true. I should make another video about that. But remember what we've been talking about. You, as the accused, do not have the burden. The government does. Every statement you make is another opportunity for investigators to misunderstand you, remember something differently than you intended, or use your own words against you. That's one of the reasons that criminal defense attorneys are constantly telling people to exercise their right to remain silent. Not because silence makes you look innocent, not because silence guarantees you'll never be charged, but because the Constitution doesn't require you to help the government build its case against you. Now let's talk about juries. People often think the jurors are asked one simple question: do you think the defendant did it? That's not what the question is that they are asked. The real question is, has the government proven the defendant guilty beyond a reasonable doubt? That's a fundamentally different question. The jury isn't there to reward suspicion. They are there to determine whether the government has met its burden. And if it hasn't, the verdict must be not guilty. Whether people like that result or not, our system was deliberately designed to make criminal convictions difficult, not impossible, just difficult. Because the people who founded this country understood something very important. The government is incredibly powerful. And if it becomes too easy for the government to take away someone's freedom, eventually everyone's freedom becomes less secure. The burden of proof protects guilty people. Yes, that is true. But it also protects innocent people. And ultimately, it protects each and every one of us. Because none of us gets to choose whether we'll someday be falsely accused, misidentified, misunderstood, or simply caught in the wrong place at the wrong time. If you remember only one thing from this video, remember this: you never have to prove you're innocent. The government has to prove you're guilty. That's not a loophole. That's one of the foundations of a free society. I'm Joel Chorny. Remember, you have rights. They matter. Protect them. Stay safe, and I'll see you in the next video.